I call this meeting to order. Welcome to meeting number 14 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of Thursday, March 31st, the committee is meeting to study Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substance Act. Today's meeting is placed in a hybrid format pursuant to the House Order of November 25th, 2021. Members attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. I'd now like to welcome our witnesses, but before I do, I just want to say I use some real simple cue cards so I don't have to rudely interrupt you. And when you have 30 seconds either in your opening statement or in the questions, I'll raise this, and when you're out of time, I'll raise the red card. So please be mindful of that and just adjust your time accordingly. So today we have in our first round of witnesses, Dr. Julie Desouris. As an individual, she's the full professor of law at University of Laval. We have Annie Sampson from Municipal Affairs Strategic Advisor for the CBC, and from the Association des Services de Réhabilitation Sociale de Québec. Is David Henry, Executive Director, and from CRC Cure Label, it's Raymond Kontnik, Executive Director. So I will begin as individuals, the first 5 minutes to Dr. Julie Desouris, please, for 5 minutes.
Oui, bonjour, alors.
Yes, hello. Thank you for this invitation. It's a pleasure for me to come and speak to you today. So just give me 2 seconds so I can put my timer on, which I think will be necessary. I'm Julie Desrosiers. I'm professor at Laval University in criminal law. I'm specialized in sentencing. I've written a lot on minimum sentences as well as alternative measures in Quebec, and I'm the author with Professor Hugues Parent of a reference work on the determination of sentences used by courts. It's a treaty of criminal law, and it's cited in at many levels of the courts. And I co-chaired an expert report who wrote a report on courts specializing in conjugal violence, so I'm better known for that aspect these days. But I will be talking about minimum sentencing and alternative measures, which is what we're looking at. So I will concentrate on some aspects of this bill, and we can come back to what interests you more specifically during the question period. What I'd like to say is that this bill aims for abolishing some minimal sentences, but not all of them. There are many more minimal sentences that were adapted over the past years than those that are stated or the object of this bill. When we abolish a minimum sentence, it has little impact on jurisprudence in general, which is jurisprudence which addresses two mid-level crimes. Where it's a problem is in sort of liminal cases where the judge who has to deal with a minimum sentence has his or her hands tied. So I thought that in order to be clearer, and that's what I usually do with students, so if you're for or against minimum sentences, you have to see what the concrete problems, the concrete situations are. So there are two problematic situations that appeared in Quebec jurisprudence recently. The first is to fire a firearm with intention. So a crime that one would think is linked to street crime, to organized crime, and which is applicable in all situations. So in this event that took place, it was a suicidal Indigenous youth who is drunk, who fires his weapon over his head to a police officer who was called by the wife of this person. And so he gets a minimum sentence of 4 years. So we have to think that minimum sentences also are applied to accomplices. So here there's a young woman of 19 years of age has a minimum sentence imposed on her because she was the driver for her friend who had a robbery sentence. So she received a 4-year minimum sentence. So the abolition of minimum sentences has come up because it provides the judge the discretion to determine in those situations who does not deserve such long sentences. And I'm very happy this possibility to give a sentence with reprieve. And so having limited the possibilities of conditional sentences has applied to Indigenous people. So, and also of, I want to talk about alternative measures in terms of problems with drugs, that we shouldn't be afraid about using alternative measures, because the possibility here do not affect any possibility of using this in courts where it's required for reasons of public safety. I'll stop here, given the time that I have. That's much too short, and we can come back to this during the question period. So,
Annie Sampson from CBC. Oh, you're on mute.
Pardon. Alors, merci beaucoup.
I'm sorry. Thank you very much for having invited me today to appear before you. I am speaking to you as a former municipal councillor. I was there for more than 25 years in a very multicultural area of Montreal with a high rate of criminality, the cradle of street gangs in one of the poorest neighborhoods in Canada. So you would see that I understand the situation of street gangs, and I wanted to talk to you about this and about weapons. So I was also responsible for public safety. So why bring these changes? I was looking at how it was bring this. It was look at mandatory minimum sentence associated with Black and marginalized Canadians who are over-incarcerated. So I'd like to also talk about a different perspective. The victims, major cities such as Toronto, Vancouver, and Winnipeg, where there were 850 gun crimes in Winnipeg in 2021. So it's the most criminalized city in 2021. And over the past 2 years, there's been a great increase in the number of shootings. Young teenagers have lost their lives simply because young people have had access to illegal guns. So these actions have destroyed families, friends, and lives. It's too easy nowadays to obtain illegal weapons in order to commit crimes. The problem here is not legally registered handguns, but those purchased on the black market, so in the street. Knowing the source of the problem as well as entry into our territory, it would be appropriate to legislate improved control measures at the borders and on the periphery of Indigenous reserves in order to limit the trafficking. We know that's the source of the problem. So what will be the impact? I'm speaking quickly because I have a lot to say. What will be the impact of reducing MMS on offenders? The street gang phenomenon, as well as criminals, know how to get around the current law. Older gangs often use younger gang members, who are often as young as 12 to 13 years old, in exchange for money to do their dirty work. Shooting up houses to send a message, shooting up young people as a warning. This happens regularly nowadays, and especially smuggling drugs, knowing full well that if they get caught, their punishment, their sentence, will be minimal. What does Bill C-5 do to protect our young people and discourage them from doing this? Nothing to discourage them. On the contrary, by abolishing MMS, we are reinforcing the impunity of this type of action. So how do you tackle over-incarceration rates? The summary document of the amendments to Bill C-5 provides statistics showing that the overrepresented population in prisons, namely Indigenous, Black, and marginalized communities, should be treated differently. However, a criminal using an illegal weapon, regardless of its origin, remains a criminal. It would be incomprehensible to let criminals use firearms, kill, steal, threaten people without facing the same consequences as others for the same crime. Is this the solution proposed in Bill C-5? Does it serve to reduce the prison population from these communities in order to rebalance the statistics? Do you know that the victims of street gangs are also overrepresented and come often from these same communities? So the solution, in my opinion, lies in working upstream. Is it normal that in 2022 our 12 to 13-year-olds have to buy protection from older kids in their schools in order to make sure they don't get beaten up during the day? And even now, as I'm speaking to you, a young man was knifed in Saint-Michel at lunchtime with a criminalized youth. Prevention programs targeted at these problems should be set up in the poorest districts to start with. By knowing the problem, then you can put programs in place, and I can talk to you about them in the question period if there are any questions asked of me. I would like to close by saying that this law will decide what kind of society we want to leave our children. Prevention and repression are the solutions. I remain concerned about what these changes might do to reduce crime if we reduce mandatory minimum sentences. We worry about our criminals in prison while hundreds of families mourn the loss of loved ones. Shouldn't the law defend citizens rather than protect the rights of criminals? And I'll close by saying one is not born a criminal, one becomes a criminal. And violence has no color, neither does death. Thank you.
Next to David Henry of the association.
Bonjour, merci.
Hello. Thank you for having me come and speak today. I'm General Director of the Association of Rehabilitatory Services in Quebec and a criminologist. The ASRSQ is a group of more 70 community organizations that provide rehabilitation services to more than 35,000 people in the justice system every year in Quebec. From my perspective, the main problem with Bill C-5 is that it addresses only some, not all, of the mandatory minimum sentences that should be abolished. It leaves in place the most severe mandatory minimum sentences, including the mandatory life sentence, which runs counter to a penal policy based in part on the principle of rehabilitation. So for the greatest part of Canada's history, there were about 10 mandatory minimum sentences in the criminal code. Now there are 73. There are only 20 mandatory minimum sentences that are targeted by Bill C-5 for repeal, either entirely or in part. It should also be noted that 28 mandatory minimum sentences have been declared unconstitutional by at least one court over the years. In my opinion, it's absolutely necessary to restore judicial discretion to sentence according to the structure and principles of sentencing set out in the criminal code. The fact that mandatory minimum sentences are abolished doesn't mean that the sentences will be less severe. It's just giving discretion to the judge to give an appropriate sentence according to the context of the crime and of the person who's committed the crime. The mandatory minimum sentences are unfairly harsh, especially for marginalized people, women, and Indigenous people. Personally, I don't understand the lack of confidence that MPs have in judges giving appropriate sentences. I'm not aware of any studies that link mandatory minimum sentences to crime rates. So, mandatory minimum sentences do not protect our communities, and several criminological studies have already shown the opposite, that a sentence or release conditions that are too severe even tend to increase the recidivism rate. So the association supports Bill C-5, but it should be amended to ensure that judges have the discretion to not apply mandatory minimum sentences that are not repealed by the bill, if doing so would cause an injustice. Thank you, and I'm available to answer your questions. Thank you very much.
Mr. Kontinek. So, Mr. Kontinek, for the remaining 2.5 minutes.
Yes, hello. I'm Raymond Cotonek. I'm a Bachelor of Social Sciences with concentration in criminology and a Bachelor of Social Sciences with a concentration in sociology from the University of Ottawa. And I'm General Director of the Residential Community Centre, which is a transition house in Saint-Jérôme in the Laurentians that has been functioning since April 1993. The changes proposed in Bill C-5 will give judges more discretion for imposing penalties or sentences on individuals convicted of certain firearms, weapons, or substances offenses by removing mandatory minimums for incarceration in those situations. Some individuals did not have a criminal intent at the time of the offense or were not aware of the severity of their actions in relation to the potential legal consequences and impact on society. The criminal code must not further restrict judges' sovereignty in sentencing. The Canadian government must trust in judges' judgment, that they have the necessary judgment and experience when determining the appropriate sentence to the crime. The justice system can no longer afford to convict people who do not deserve the harsh sentences imposed by mandatory minimum sentences, especially when there is no real or direct victim. In these cases, there is no need for minimum sentences. We must consider the harm done to victims and to the community. The consequences of a criminal record are significant for offenders, and in some cases they become cruel and disproportionate to real consequences to the potential victims of that same offense. Some individuals who have committed a crime pay for their actions for the entire rest of their lives, even if there was no actual victim. Having a criminal record can prevent them from getting a good job, a promotion, a loan, and reasonably priced insurance, or from being able to travel outside the country to become a citizen again. So in these cases, the mandatory minimum sentences imposed by judges can be more severe in terms of diversion. It would be important to modify current procedures so that the offender be referred to a therapeutic measure, such as a cure, rather than a punitive measure, such as prison, because then recidivism becomes almost inevitable.
Of questions, beginning with Mr. Moore from the Conservatives for 6 minutes.
Great. Well, thank you, Mr. Chair, and thank you to all of our witnesses. As we deal what is a very important bill, I know from some of the background, some of the rationale behind the imposition of mandatory minimum penalties. Some of them have been with us for a very long time, including many that are being repealed that trace their origins to the 1970s. And know that at times it's our job as parliamentarians to put into place laws that we feel provide balance for the justice system and balance the seriousness of the offense, as well as the protection of our communities and the input from victims and their families. So from Ms. Sampson from Municipal Affairs, your strategic advisor, a former mayor in the Montreal area, former head of public security in Montreal, so you certainly can speak with a lot of experience. And I don't know if you saw the article, but your testimony made me think of it. Recently, we saw they were using drones to try to bring handguns into Canada, and that's what we're hearing from our expert testimony, is that a lot of the firearms that are being used criminally are in fact illegal firearms that are brought in from outside the country. So, unfortunately, in an effort to deal with gang and gun crime, we see the government, number one, is cracking down on law-abiding citizens, and then number two, providing softer sentences for firearms crime. And some of this is serious weapons offenses, weapons trafficking, extortion with a firearm, robbery with a firearm. I fail to see, as one of the witnesses just mentioned, how someone could, without intent, commit robbery or extortion with a firearm or traffic a firearm. But be that as it may, you have called on the Prime Minister to take action to curb gun violence, and you mentioned the lack of respect for life, the feeling of impunity of street gang members are favored, among other things, by the laxity of the laws in Canada. So you've already, as someone with a lot of experience, have found that there is an impunity. What do you think the criminal element will make of us weakening the laws when it comes to gun crime?
Vous avez bien résumé ma pensée.
Well, you really summed up my line of thought. What's important to say is that nowadays, if this act was presented 5 years ago, before the pandemic, before the increase in crime, everything was going down, there would have been no problem. We'd have thought we're going in the right direction. But over the past 2 years, unfortunately, the rate of use of illegal guns, and not the registered ones, it's the illegal ones. These are now in the streets. People buy them on Instagram at school. There's a weapon on the photo, and so the youth makes an appointment with the other one, goes to get one, and then let's go. Let's just cause problems to the young ones in the park because we don't like them. And what's important to underline right now, it's this ease of accessing this violence, of wanting to shoot wherever you want without being afraid of being caught, because we think, well, we'll be caught. It'll be the first time. We're young. We just get a reprimand and we won't do it again. But once we cross that line into criminality, I have organized prevention programs starting at the age of 5. When I went into to primary school, their brothers had the mandate of dealing with drugs or delivering drugs in the schoolyard. So we have to give to those people the possibility of having access to programs, to sports, of getting enough food, and to know what is good and what is not good. And we were able to do that over 15 years. We changed an entire generation. But currently, those youth are getting older. And when the young people cross this line of this boundary of criminality, and it's often due to poverty, to their social milieu. But when a father came to see me, for example, my father said, I want my young guy to go to university. This is a youth from the Haitian community. So this is a taxi driver who says, my son's in Canada, I want him to go to university, I want him to get a good paying job. So his youth says, well, you know, Dad, this weekend I made the salary that you get in 1 month. Why would I go to university? That youth was a street gang member. So it's really easy. That's how it is for them. And so when you ask those people, those youths, what do you want to do in life? They say, I just want to survive my day because I don't know if I'll still be alive tomorrow. So that's the daily experience of the Saint-Michel youth.
Testimony indeed. As you know, as a former mayor, it's not only the individual that's sometimes victimized, but communities that are put at risk. What do you think the message to our communities, both urban and rural, is if we pass C5 when so many of these communities are struggling with gun violence?
Unfortunately, we're out of time, but if you could submit that answer afterwards or hopefully answer it subsequently, that'd be great. Next to Madame Briard for 6 minutes, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question is addressed to Professor Desrosiers. Thank you very much to all the witnesses who have come to be with us this afternoon. I imagine that you're Maître Desrosiers. In your evidence, you talked about the broadening of the conditional sentences orders. So you said that by limiting them, there had been, as a result, the overrepresentation of marginalized communities incarcerated, including Indigenous people. So I'd like to hear what you have to say about that. And I'd also like you to speak to us about the too simplistic equation of imprisonment and the objectives of dissuasion. So conditional sentences was brought in 1996, which was to empty prisons of people who had short prison sentences. No one ever questioned imprisonment for serious crimes that were a threat to public safety. That was never discussed at the government level in Canada. But the recourse to imprisonment for short sentences was questioned because the counter effects of imprisonment are much larger than the positive effects. And there is no divergent opinion about that. No criminologist will ever question the fact that short prison sentences are harmful. So in Canada, the overwhelming majority of sentences are less than 6 months imprisonment. And even then, there's most of them are less than 3 months, so 60%, and even some that are less than a month of imprisonment. So those sentences could have been avoided, and one could have had recourse to another kind of sentence. But another kind of sentence has to be invented, that one can have a punitive potential, not just observation in the community. And that was our invention in 1996. That's why I said there's a strong potential there. We wanted to have home-based imprisonment. So the judges their power was reduced. So conditions were saying if it's a crime that's not dangerous for the public, you can imprison you can give a conditional sentence in the community. But by preventing judges from doing this, the consequence was, well, I don't have a conditional sentence. I don't want to send this person in jail, so I'm stuck with that. So I will have intermittent sentences. So we had an increase in what we call weekend incarceration, so less than 90 days, but the person is able to serve them on weekends. But the Indigenous people can't do it because it's too far from their communities. So that was decried by the Viens Commission that said Indigenous people don't have access to this, so they have to serve their entire sentence in jail. And so this increase of these short sentences, there are minimum sentences of 45 days, so it means that you still have to impose it when you're judge. You cannot have recourse to a conditional sentence, and that also contributes to the increase in prison time. And the reason why it targets Indigenous people is because in some communities there are more drug-related crime. So then we'll have more Indigenous people in jail. And the other part of it, the general dissuasion effect of imprisonment was never demonstrated. It's recognized in law. It's not an object of controversy. In the Nure decision, the Supreme Court invalidates a minimal sentence in weapons case. And I can't prevent myself just to interject in the previous topic to remind us that minimal sentences cannot be imposed on adolescents. So the problem of organized crimes and firearms is real in Canada. Those described by Madame Sanson are real problems. I'm just questioning the solutions that she is presenting, because it's not by imposing minimum sentences in the criminal code that will keep these adolescents responsible, because these are not applied to adolescents, and everything shows that it is prevention, re-education, social reintegration measures that have an effect on adolescents. And she did provide important aspects of the problem, mentioning poverty, education, and integration problems, because the weapons in the streets problem is much broader than that and much more complex than that, than recourse to criminal law. And as MPs, I would tell you that if you tell the people in your ridings that you're going to solve the problems of weapons in the streets and organized crimes with minimum sentences, that's completely wrong. You wouldn't be able to solve those problems. Thank you.
Thank you. Now to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Well, first of all, I acknowledge and I appreciate that we have a panel of Francophone witnesses today. It's really refreshing for me. It's really good to hear. And I'm happy that my Anglophone colleagues have this opportunity to appreciate having some good French content at our committee. So I say these are important testimonies. Madame Sanson brought up facts very different from those of Madame Desrosiers, Monsieur Kotonik, and Mr. Henry, and that this will lead us to really think about this. This is a question for Madame Desrosiers. When I heard all the evidence, those that we heard previously and today's, we see that there is an important concern on the part of many witnesses, and also when we read in the papers, we see that the population is concerned about the rise of crimes using firearms. And I agree that it's not by imposing minimum sentences or increasing the minimal amount of time spent in prison that we will deal with the problem. But I tend to agree with the evidence heard that it tends to complicate things. But we're not here to judge. We're here as legislators, and we have a responsibility, which is to respond to the needs of the population. So when I hear Madame Sanson, who's a former mayor in Montreal, in Saint-Michel, that's where she works, I hear her concerns when we're talking about youth who are handling firearms, who can buy them on Instagram. When we think about youth people, even 5-year-olds in the schoolyards are dealing drugs. It's incredible. So it's true that mandatory minimum sentences don't apply to them. But when we decide to abolish minimum sentences for some crimes, I think that we're sending a message to the population, a message that's not necessarily the one we want to communicate. Anyway, I don't think anyone in Parliament would think that we have to tell the population that it's not serious to be handling firearms. I think we all think it's serious, especially when we talk about prohibited weapons. So my question for Madame Desrosiers is, are there not alternatives? Are we maybe not too locked into a situation of for or against minimum sentences? I'd like to ask Madame Desrosiers this. Is there a way of reassuring the population, of confirming that we are not nonchalant, that we have these concerns in relation to these crimes, but we will give the courts a sufficient margin of maneuver to provide a appropriate answer? Yes, I will answer. I have 3 parts to my answer. The first thing I'd want to say is that the problems raised by Madame Sanson are of grave concern. So I am concerned by these problems. And I think that as MPs, you have to address them. What I'm saying, it's not minimum sentences that will solve the problem. And I'm telling you, and I'm convinced, I'm saying this based on several studies, that you have to do more. There's nothing easier than just adopting a law that prescribes a minimum sentence. That's the easy solution. But it's a complex problem that requires investment. It requires public health measures, education measures, negotiations with Indigenous communities, all kinds of actions that are much more complex and difficult than the adoption of a law imposing minimum sentences, which sends a false message to the population of false actions. And that's my first point. My second point is the fact that the hope of a message of dissuasion And this idea that because a legislator adopts a minimum sentences, he or she sends a message, has never been demonstrated at the empirical level. Most people have no idea of what minimum sentences are in the country. So it's not something that has been demonstrated. People don't know what minimum sentences are. When we adopt one, they don't necessarily know what applies, when, and to what. So I don't think that we can rest on that. And the third point, I don't know what you're going to decide. I have my teacher's role, so I'm giving you the information that I have, and I'm very convinced about what I'm saying. You have your roles as legislators. You have pressures that I don't live on. But if you decide to conserve minimum sentences in some cases, you should very strongly bring in a possibility of not doing it in exceptional situations, so that there can be exceptions. You said this exists, but you do give the power of judges in exceptional circumstances to not apply this, because exceptional circumstances do exist. Reality is complex, and it's not just made up of hardened criminals who sell firearms to children. There are all kinds of things that happen in reality. All kinds of situations are presented in the courts, and sometimes a minimum sentence is not appropriate. Thank you. Madame Desrosiers. We have 30 seconds. So are there places in the world where there is this regime of exceptional circumstances that you have brought up? Yes, it's very frequent. For example, in France, there are minimum sentences with the possibility of exemption. So the if you go to NUR, if you go to LOG, you will see clear signals for the Supreme Court to be able to bring in this kind of measure of exceptional circumstances. Thank you very much.
Thank you very much, Mr. Chair, and thank you to all the witnesses for being with us today. I want to stay just a moment with Dr. Desrosiers on the question of restoring judicial discretion. We've heard this suggestion from many people. We have a technical problem as legislators in that we're dealing in this committee with a bill as drafted, and it's difficult for us to see, for some of us to see, how we can amend this bill to restore that discretion. I wonder if you have any suggestions as a professor dealing with this of how we might go about that, because this bill doesn't deal with all mandatory minimums. It only deals with a select number.
Absolument.
Absolutely. Already, I think that you can, in any case, return this bill so that more can be added to it. But there are two parts to my answer. The first one would be what to do with existing mandatory minimums that are targeted in the bill. Even for some crimes, the bill doesn't deal with all the minimums for everything. So discharging firemen has several different mandatory minimums, and the bill just wants to have it discharging a firearm when it's not a prohibited weapon. So I just wanted to start with that. So around this first discussion about the bill, you will be having discussions as parliamentarians, and I don't know whether you all agree on the desire to remove all these minimum sentences. But one thing is certain, with what you have in the bill, it's always possible to say the minimum sentence in paragraph 2 is applicable except in exceptional circumstances. That's what's used in other jurisdictions. So unless there are exceptional circumstances, and those keywords restore the judicial discretion, because if the judge faces exceptional circumstances, the judge can not apply the minimum sentence. And there's a possibility of adding a provision briefly without talking about all the minimum sentences in the code, because there it was done article by article. But what I'm proposing, and it was also proposed by my colleague Henri, I'm not the only one to say it. Several people have already thought about this question, but it can be done by a general provision in the part related to the sentences. So there's a whole part on sentencing. It starts with Article 68 of the Criminal Code, and you can add a general provision saying each time that the code prescribes a minimum sentence, the judge can have discretion in exceptional circumstances. So that could be added to the bill, and it would solve the problem for everything. And really, these general provisions are welcome in the criminal code. We have a criminal code that's very patchwork, so there's no general direction. But if we could send a message to all judges saying that if you have a minimum sentence, you can have discretion in exceptional circumstances.
To turn to the Association for Rehabilitation in Quebec and Mr. Henry, Mr. Contenac made a reference to the effect of criminal records on the ability for people to be rehabilitated and reattached to society. Again, something that's not in the bill, but something perhaps we will be able to add to the bill. But could, Mr. Henry, could you talk about the impact of criminal records for personal possession of drugs and the rehabilitation process?
Oui, merci. En fait,
Yes, thank you. So if we're talking about the criminal record, there's no gradation in the law as far as this is concerned, regardless of what it is. If it's a murder or something else, the person will have a criminal record once they are found guilty, and there's no absolution. And the consequences are the same. There aren't any different kinds of criminal records. So I don't know, as parliamentarian, you know that there are 4,200,000 Canadians who have a criminal record, and that this criminal record, regardless of circumstances, is never erased before the age of 125 years. You can have a suspension of the criminal record, but the criminal record is just suspended. It's not suppressed before the age of 125 years, regardless of the severity of the crime. And the problem of the application of this law is that the criminal record, as such, will discriminate against people long after they've served their sentence. And that has an impact on their job seeking, given that there are more and more employers who will look at people's criminal records through court registry, for example. And an employer can look up someone's criminal record without their consent. You just have to have the family name of the person and their date of birth. And many people on Facebook make their birth date public. I could check anybody's criminal record as long as I have their name and their date of birth from the information systems at the courts. And so many businesses use those services to discriminate against people who have a court record when they're hiring without looking at the details of the crime. And there are also other consequences. I've used up all my time. Sorry.
Harrison, next we have a 5-minute round, beginning with Mr. Brock.
Thank you, Mr. Chair. And I'm going to start off by asking the same question that my colleague Rob Moore asked Ms. Sampson. And Ms. Sampson, the question again, to refresh your memory, can you share with the committee what message C5 sends to communities who are grieving due to gun violence?
Le message qui est envoyé actuellement,
The message that's currently sent is that the criminal can commit a crime, and with the abolition of mandatory minimum sentences for shorter sentences, means that the criminal is punished, but the victim might be traumatized for the rest of his or her days, and their life will change completely. Whereas one is concerned with rehabilitating the person who has hurt the family. But the person who was attacked, who was injured in circumstances of the crime will have to live with that for their entire life. This can really change the course of their life. The person can become depressed, can leave school, can ruin their life. Someone who might have had a great future who will no longer have one because either the person was raped or attacked. All sorts of things happened. But the author of the crime might have been punished for a year, maybe with home imprisonment. The other person has this experience for life. So I wanted to bring up this vision of a criminality which has long-term effects on the victims that we don't see, we don't hear. And those shootings in Montreal led to the creation of a committee in Montreal, the Citizens in Action Against Violent Crimes. We did that because we're looking for solutions. We wrote letters to governments. Here are the amendments you could make at the provincial, federal, municipal level. There were solutions. And after that, we received a lot of calls from parents of the victims who had nowhere else to be heard, where they could be respected. We met for 3 evenings 2 fathers who lost their sons tragically, children who had nothing to do with crime, who were shot, who were killed for whatever reasons. But so this woman who was a doctor went into serious depression. The father lost their work. Their twins left school. It completely destroyed that family that has a great grief without any response. And when that criminal was found, because it's not a minor, and if that law were accepted, there would be a penalty, but it will never solve the grief, the trouble, the destruction of the family that experienced this. And we've seen several cases like this, and we receive emails. So it was a good way for us to try and help people, but it's almost a full-time work because we're receiving calls from teachers in school who are saying, come and tell our children what to do. Come and give us some signs. And we're really trying to find ways to put a balm on the grief of these parents, on their distress. And so maybe there are good reasons to do it. There are exceptional cases, but we will need some kind of pedagogy to be able to convince those victims who feel abandoned by the system currently. And it's very much that is hard to accept when we talk to them. There's another of our colleagues who will be coming over the next week to testify. I think it'll be Friday, who will also relate to you this kind of phenomenon. And in that group, it's police officers who created it with me. We have police officers working in the field who do apply the law, enforce the law, and I'm on the other side, and I want to be there to help our youth to get out of this, and that's where we are. We have to find a way of doing it. And as you said, Professor Desrosiers, there are certainly measures that have to be put in place to help these people living in pockets of poverty, to help these young people get out of it. And that's why I said that repression and prevention go hand in hand. And when we impose or bring major measures of preventions with funding to find the source of the problem, to deal with it, to allow young people to have to be safe, to go to school, to go against quitting school, and offer them opportunity, we may have a better society and less crime. I hope I've answered your question.
Thank you, Ms. Sampson. Next to Madam Shanahan for 5 minutes.
Thank you. Thank you, Chair. I'm all tied up in my earrings and my earphones and so on. Thank you very much. Puis merci beaucoup.
Thank you very much to all the witnesses who are here with us today. And really, these are very interesting discussions related to a problem which is of great concern to us. Mr. Henry and Mr. Cotonec, we've already heard Madame Desrosiers speak about the terrible problems that Madame Sanson described. Do you have any specific reaction to share with us? Well, maybe I could add. Professor Desrosiers really gave a good synthesis of my opinion on mandatory minimum sentences, but I'd like to come back to what Madame Sanson said, if you'll allow me, because I have this idea that the rights of victims and the right of prisoners are opposed systematically. I would like to know how mandatory minimum sentences would offer a certain comfort to people who have been the victims. And it's not because we work in rehabilitation that we don't empathize with the victims. To the contrary, so we shouldn't oppose these two things. So it's not because the members of the association work on the rehabilitation of offenders that we're working against victims. So we want restorative justice measures that really involve the aggressors and the victims together to solve these conflicts. So both victims and offenders need to be accompanied, need structure. And the mandatory minimum sentences do not serve the victims. So they have been the victims. The fact that the person is condemned to 1 year of prison, or I don't see how that would comfort that person and help them get through what they've experienced. And for the aggressor, as Professor Desrosiers said, there are many circumstances. Well, there are exceptional circumstances that will mean that mandatory minimum sentences should not always be applied. The judge's or judicial discretion is important, and in your mind, you have to realize that the fact that we abolish mandatory minimum sentences makes sentences less serious. The judge decrees the adequate sentence, which will sometimes be more severe than the mandatory minimum sentence, and sometimes less so in exceptional circumstances. But it's not trying to make a system less punitive. So those are two things that are entirely different. Thank you very much. I would like to continue with Mr. Cotonek. Could you tell us about the damage that mandatory minimum sentences cause to individuals, especially those who live with addiction problems, also to their families and to communities? And I would like to know more about the negative effects on families, especially the children of the incarcerated people. Yes, well, actually, what we have realized here in our transition houses that our clients often have completed part of their sentence, either 1/6 or 1/3 of their sentence in jail, and are often completely disconnected from the daily lives of their children when they come back in the community, because it's often their spouses who took care of the children for all that time, months and sometimes even years. So to take their place in the parental authority structure, in the family structure, is very difficult because the children are often, feel that it's a stranger who's in the house because there's not necessarily any credibility in the eyes of their children. So it's a difficult experience. And as Mr. Henry has said, I agree with him, the minimum sentences in situations where it's a crime that might be the least serious, if they existed or exist or not, I think that we really have to trust judges. And yes, the sentences will be heavy in where that needs to be the case. I don't think we have to think that if mandatory minimum sentences are not there, that everyone will get light sentences.
Now we'll go for two quick 2.5-minute rounds. First with Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question is for Mr. Cotonek. Mr. Cotonek, I'd like you to I understand that you're working in the rehabilitation sector and people who've already been through various penitentiaries and then are with you. I'd like you to talk about recidivism, repeat offenses. How can we evaluate the rate of success in terms of rehabilitation related to people who come back? And second question, do you not have the impression sometimes that your clientele, if I can use that word, that not everyone realizes the seriousness of the acts committed? Or do you have the impression that once they've been through that process, they've understood and they don't have repeat offenses? So for those who go through transition houses, because I believe in our mission, so our mission of a halfway house, a transition house, is social reintegration. Yes, that is our mission. But the main thing for us is societal protection. During the time they are here, recidivism is zero. And I haven't seen any recidivism. What I see from time to time are violating the conditions of, but maybe the guy will drink some alcohol one evening and gets caught, and there are consequences internally, and might go back into detention. But there is no recidivism. So recidivism after they've been in the halfway house, there are statistics. Maybe Maître Desrosiers knows more about them than I do. But since 2006, we've been keeping statistics on our successes, and it's about between 87 and 94% success. So over a group of 100 residents that would go through the halfway house. So I said between 87 and 94 are successful. They will complete their time with a job, with housing, and also a place to maybe start or end therapy. Thank you. We have 20 seconds left. Oh, sorry. I'm finished. I didn't realize it. Sorry.
Next to Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I want to continue talking about the idea of rehabilitation. I guess what I'll pose, I think, either to Mr. Henry or Mr. Kotenek is, if we didn't pass this bill, most of the mandatory minimums we're talking about eliminating would remain in place at 1 or 2 years. If people are being sent to institutions for less than 2 years, what access do they actually have to rehabilitation in those cases?
I don't know who the question is for. Was it for Mr. Kotenek or was it for myself? Well, for short sentences, for less than 2 years, that's managed by the provincial correctional system. And so in Quebec, it's the Quebec Correctional Services who assume responsibility for people who have sentences of less than 2 years. And the system works like it does in the federal, that there are outing permissions. Well, to sum it up, in some cases, it's possible to get out after 1/6 of the sentence. So the sentence continues, but the person leaves detention after having purged 1/6 of the sentence. It's very unusual, applied seldom, and that's decided by the Quebec Parole Commission. But someone else for less than 2 years can have go on parole after the third of their sentence, and it's the commissioners of the Quebec Parole Board who would agree to this for the person as a function of their potential of social reintegration. Also, their plans for coming out. Often these people will be found in a halfway house and will be supervised for the remaining 2/3 of their sentence in community. And studies have shown that people who do come out on parole and who are supported to the end of their sentence are less likely to repeat offenses or to offend again than people who come out at the end of their sentences after having purged 2/3 of their sentence for a 2 year or less sentence will be freed without any support. And so there are more repeat offenses for people who come out sooner but who are supported. So for me, rehabilitation requires services, mentoring, support that we offer people when they come back in the community. We can give programs in detention, but as Professor Desrosiers said, the provincial sentences are very short.
Garrison, that concludes our first panel. So I'm just going to suspend for a minute to do a quick sound check for the next panelists. These panelists are dismissed, and we'll do some sound checks. You're more than welcome, by the way, to stay on and listen to this, but in the interim, we'll get our new panelists set up. Thanks. We'll resume with the second panel. Just quick reminder to the second panel, you'll have 5 minutes each to make your opening statements. I just have simple cue cards, and when you're down to your last 30 seconds, I'll raise this and when you're out of time. So please be mindful of your time, and if you miss anything, get it out in the questions when they're asked to you. So our first panelist is Elizabeth Kaiser-Derrick. She's a PhD candidate. So 5 minutes for you.
Sure, thanks. It's Elspeth. Good afternoon. First, thank you so much for inviting me to appear before this committee. I feel very honored and grateful to be here with you. At the second reading stage, Bill C-5 is framed in relation to the overrepresentation of Indigenous peoples in the system, alongside Black people and those from other marginalized communities. I will focus on this issue of specifically Indigenous overrepresentation. For some context, my research draws upon feminist theories to explore how the criminal justice system interprets and characterizes information about women processed through it, and particularly Indigenous women. In my book, I reviewed 175 decisions sentencing Indigenous women spanning from 1999 to 2015, beginning when the Supreme Court of Canada issued Arvis Gladue, which interpreted Criminal Code Section 718.2e and set out a different methodology for the sentencing of Indigenous people. That court affirmed and clarified this in the Queen and Epeli in 2012. In Gladue, the Supreme Court finds that Indigenous peoples are overrepresented throughout the system, cites systemic discrimination, and declares that this is a crisis. The court determines Section 718.2e represents a direction by Parliament to the judiciary to strive to remedy this. The court outlines that judges are required on a mandatory basis by Section 718.2e to consider all options other than imprisonment. The Truth and Reconciliation Commission, the TRC, in its Call to Action 30, directs all levels of government to commit to eliminating the overrepresentation of Indigenous peoples in custody within what remains now as the next 3 years. In its Call for Justice 5.21, the National Inquiry into Missing and Murdered Indigenous Women and Girls calls upon the federal government to fully implement this and other recommendations by the TRC and other bodies pertaining to the overrepresentation of Indigenous women in the system. In both Gladue and Epeli, the Supreme Court of Canada acknowledges the limits of the sentencing process to remedy the injustice of Indigenous overrepresentation in the system. Each decision finds a measure of optimism. In Gladue, that optimism rests in that judges determine most directly whether an Indigenous person goes to prison. In Ipali, there is some residual optimism in its clarification of how judges should apply Section 718.2e. However, Gladue was decided over 20 years ago, and Ipali was decided a decade ago. In the most recent annual report from 2020 to 2021, the Office of the Correctional Investigator indicates that the population of Indigenous women who are federally sentenced has increased by 73.8% over 30 years, representing 43% of all federally sentenced women. I also note that because CSOs are only available for sentences within provincial terms of under 2 years, that particular element of the bill, C5, will not apply to Indigenous overrepresentation at the federal level. In my book, I explore the sentencing of Indigenous women through the lens of a feminist theory called the victimization-criminalization continuum. This theory provides a way to understand women's trajectories into the criminal justice system as connected to their experiences of victimization and constrained options arising from that context. I use this framework broadly, including to encompass colonial harms within the context of within the concept of victimization. Among many others, my research includes cases in which Indigenous women's criminalization or incarceration led to the apprehension of their children by the child welfare system, and also the inverse, where Indigenous women did not contact police or medical authorities where necessary because they feared that their children would be apprehended and then became criminalized as a result. I believe that these and related junctures where colonial systems and institutions intersect contribute to the entrenchment of Indigenous overrepresentation in the criminal justice system. I also note that approximately 80% of the women in my research are mothers, and Indigenous children and youth remain highly overrepresented in child welfare systems. I offer these examples of some Indigenous women's criminalization because any legislative amendments to mandatory minimums and CSOs that are positioned to respond to systemic discrimination, overrepresentation, must provide judges with flexibility to account for these and other colonial complexities. Over 30 years ago, the Aboriginal Justice Inquiry of Manitoba examined Indigenous over-incarceration in that province, recommending that trial judges must be more creative and flexible in sentencing and that appellate courts must encourage this. The Supreme Court of Canada in Ipali also points to the need for innovative sentencing. However, greater judicial discretion is necessary to fulfill this need to craft just sentences generally and specifically per Section 718.2e. In my research, some judges explicitly stated that they could not order community sentences that would otherwise be fit due to legislative restrictions, and other judges made comments signaling a need and desire for more creative sentencing reasoning and practices for the Indigenous women before them. In my work, I argued for an expansion of the availability of CSOs and suggested a legislative way forward through this through judicial discretion, such as to decline to impose mandatory minimum sentences where appropriate. Indeed, the TRC's call to action number 32 directs this. I have a small bit left, but I've run out of time.
Thank you, Ms. Kaiser-Derrick. Hopefully you'll be able to finish that off in one of the questions. Next to Mr. Mackey for 5 minutes from the Council on Criminal Justice.
Thank you very much, and I want to thank you all for inviting me to appear before the Standing Committee on Justice and Human Rights and present testimony on Bill C5. As you noted, I'm the director of the Task Force on Long Sentences of the Council on Criminal Justice. The task force is a new initiative that is dedicated to assessing the impact of long sentences in the United States and making recommendations that advance safety and justice. The Council on Criminal Justice, is an independent, nonpartisan think tank. We're dedicated to advancing the understanding of criminal justice policy choices and building consensus that enhance safety and justice. To be clear, the Council itself does not take policy positions. Instead, it forms working groups, task force, and commissions to study and make recommendations. So as the task force I lead has just begun its work, we have not yet come to the recommendation phase. And so while I am unable to speak to, in support of Bill C5, I can talk to you about the research findings around mandatory minimums. And to be clear, most of these research findings come from the United States, but I'm not aware of anything that would be inconsistent with them outside of the United States. So let me summarize these research findings in very general terms and then unpack 3 aspects that I think are relevant to C5. Mandatory minimums are often extremely popular, particularly in the United States, but there is almost no evidence that they deter criminal behavior. And there's also substantial evidence that they cause significant dysfunction in the courts and produce unwarranted disparities. So let me talk about quickly three findings to consider. First, mandatory minimums is really a misnomer. Mandatory minimums are not truly minimum. This is an argument that the International Authority on Sentencing, Michael Tonry, makes. And what he's getting at here is that research findings are very clear that mandatory minimums lead justice system actors, from police, prosecutors, and judges, to take actions to evade decisions that they believe will be unfair or unjust. It's also clear that these kinds of decisions have disparate impacts on particular groups, including racial and ethnic minorities. And this really points to one of the structural problems of mandatory minimums. They're based on the assumption that through mandate, you can make discretion go away. And this is the assumption, but what research shows is that mandatory minimums what they actually do is take away discretion, which is transparent and reviewable from judges, and they vest it into actors and moments that usually lack transparency and are often unreviewable, and therefore unaccountable. So this leads to, research shows, all kinds of system dysfunction. Associated with this, we see an increase in dismissals at the early stages of trials, but an increase in sentences for defendants who are convicted. Associated with this outcome, research shows that mandatory minimums increase courtroom work, length of trials, and also court appeals. Very common finding in this research is that mandatory minimums produce disparities. Research has consistently shown that mandatory minimums generate unwarranted disparities by region, courtroom, and, as the U.S. Sentencing Commission found, also by race. Finally, mandatory minimums, research is pretty clear here, do not produce a meaningful crime reduction benefit. So I want to be clear, no one really disputes the fact that criminal penalties in themselves probably produce, or certainly produce, some deterrent effect. But research suggests that the certainty apprehension is what's really important, and that severity, increasing severity, is not how you get deterrence. And so, as mandatory minimums, kind of try to use severity to get to apprehension, it probably undermines one of the core drivers of crime reduction. And so, while there is some evidence, mainly from economists, that maybe there's some very marginal impact, the overwhelming body of empirical evidence suggests there's no meaningful public safety benefit that comes from mandatory minimums. So that's my brief overview of the findings. Let me just conclude. Again, very honored to be before you and happy to answer any questions that you have.
Thank you, Mr. Mackey. I now go over to Mr. Cooper for 6 minutes.
Thank you, Mr. Chair, and thank you to the
Thank you, Mr. Chair. I'd like to thank the witnesses.
An overrepresentation of Indigenous persons caught up in the criminal justice system. Would you also acknowledge that there is an overrepresentation of Indigenous victims?
Sorry, I was muted. Absolutely, and that's at the core of my work. My work examined the sentencing, sorry, I rushed through my statement, but my work examined the sentencing of Indigenous women, and at the heart of my work was a feminist theory called the victimization criminalization continuum, which recognizes the relationship between experiences of victimization and then the criminalization in ways that they are interrelated, and it's not a linear connection from one to the other, but that there's kind of an enmeshment there. And so the Indigenous women that I reviewed sentencing decisions for in my own research, they're at the sentencing stage, their experiences of victimization might appear before the judge in the form of a pre-sentence report or a Gladue report or counsel submissions, and so they're not life stories. They're written by institutional actors for institutional purposes, but they detail experiences of victimization which are all interconnected with colonization. And so a central part of my own work is to try to define victimization broadly, such that it encompasses harms caused by state institutions. And so for Indigenous women, that occurs over time in their own individual lives and also collectively and intergenerationally. And so victimization manifests along that continuum, and including, and this is the part that is really important to me, harms caused by the criminal justice system. So by the experience of being incarcerated where that arises, by experiences associated with the criminal justice system. Some women in my research, their children were apprehended in relationship to ways that they were criminalized, or others feared or lost their homes or employment when criminalized. And so the experience of victimization is at the center of my concern. And I want to note, I hope I can find it very quickly, the Department of Justice Canada did a study that they issued a report in 2018, and they said that in that report, Indigenous women have lost confidence in a system that fails to believe their experiences, and that there was insufficient information about the specifically gendered experiences of women in the system, and particularly in the context of entrenched oppression for Indigenous women. And they suggest that the government should require actors in the system, including judges, to consider underlying factors related to criminalization, to victimization and criminalization. So the Indigenous women sentenced within the criminal justice system, there's an interrelationship there with victimization.
Okay, thank you for that. And I did want to give you a little bit of time to
Sorry
carry
if I
on
used too
where
much.
you were unable to finish off. But when we look at Bill C-5, what we do see are a rollback of a number of mandatory minimum jail sentences for some pretty serious offenses. Robbery with a firearm, for example, weapons trafficking, extortion with a firearm, and so on. I mean, of all the mandatory jail terms, it just seems to be a strange way of addressing some of the issues that you have noted exist amongst Indigenous Canadians who are overrepresented, both in the system and as victims. To say that the solution to that is to remove mandatory jail times for some very, very serious offenses.
I think it's a very complex context, of course. The part of my statement that I really rushed in the beginning was that the Truth and Reconciliation Commission of Canada, amongst their calls to action, number 32 directs the federal government to amend the code to allow judges to depart from both mandatory minimums and restrictions on CSOs when providing reasons. And I hear what you're saying, but at the same time, because the bill is framed in relation to trying to ameliorate the Indigenous overrepresentation in the system, my concern is that if Bill C-5 is not expanded to include that call to action by the Truth and Reconciliation Commission, allowing judges to depart from mandatory minimums and restrictions on CSOs, I'm concerned that the proposed amendments won't have the capacity to meaningfully address the scope of Indigenous overrepresentation in the system because of some of the things that I mentioned about interrelationships between child welfare systems and
Thank you, Ms. Kaiser-Derek. Apologize. Next to, I believe, Ms. Diab for 6 minutes.
Thank you very much, Mr. Chair, and thank you. Welcome to our witnesses as we continue to study Bill C-5. Ms. Kaiser-Derek, I want to give you an opportunity to finish your thought, but I want you to talk about conditional sentencing a little bit. In the earlier panel, we had a great panels that talked about mandatory minimum sentences, but I'd like to turn it at this time to conditional sentences and the provisions that would allow that under this for less than 2 years to be served in the community. And I want to know, based on your work with Indigenous women who received conditional sentence, would you say that these sentences allow the women to reintegrate their communities while also preserving the safety of the communities? And what would you say to those who think conditional sentences are soft or light punishment based on your studies? And
Sure. So my research did seek to highlight conditional sentence orders where possible, because given legislative amendments, I mean, the conditional, I'm sure you've already canvassed this in the previous session, but was introduced with code amendments in 1996. And then in 2000, I believe 2007, then 2012, there were incursions into judicial discretion to be able to issue conditional sentences. And so my work in part was examining how judges go through the Gladue analysis, which means looking at systemic and background factors of Indigenous people before the courts, and how that relates to the sanctions that are ordered. I was trying to look at how can judges look to alternatives to incarceration through that Gladue framework for Indigenous women, in my research specifically before the courts, if there really aren't other options. So there certainly were Indigenous women in my research who received conditional sentence orders that, following the 2012 amendments, would no longer have been eligible for conditional sentences. And so those women, may essentially, if a conditional sentence order is not available, then a judge would probably order a prison term instead, because a conditional sentence order most readily replaces a prison term of under 2 years. But some judges in my research also tried to construct probation orders that would approximate a conditional sentence order.
So, Ms. Kaiser-Derek, let me just ask another question. You talked about,
Sure.
And you continue to talk about the flexibility to have judges consider other options, said innovative, more creative. So, alternative to prison to incarceration. Why do that? Why is that a good thing when somebody's committed a crime? Can you tell me?
Sure. In my own work and other substantial body of work, the experience of incarceration has profoundly damaging effects, and certainly that can manifest in specific ways for Indigenous people generally, and Indigenous women was the focus of my work, in ways that I sort of rushed through this, but in terms of modes of colonial control over time, for example, residential schools, and then the child welfare system, and now Indigenous over-incarceration in the criminal justice system broadly, and prison specifically, the degree to which fracturing of Indigenous families is a feature of each of those installments carries really profoundly, it carries reverberating impacts on the lives of Indigenous individuals, families, communities, And so
I think,
Sure.
yeah, so I guess, would you agree that ultimately, when somebody's incarcerated and in jail, at some point, the expectation is that they're going to go back to the community? So talk to me about access to these Indigenous women, or, to have cultural counseling opportunities, and, how are they going to be integrated back to their community when they're simply sort of in jail without the ability to have conditional sentences where they can take into account a number of their cultural backgrounds?
My belief, and it's consistent with what I uncovered in my own research, is that Indigenous women need to be in their communities, in our communities, and that severing those bonds is just going to perpetuate the over-incarceration and over-representation of Indigenous people in the system, and it's going to maintain this colonial construct. And so in terms of resources,
Thank you,
I think that's a
thank you, Mr.
funding
Ki-
issue as well.
Thank you,
Okay.
Ms. Kaiser-Dirk. Thank you, Ms. Diab. Now to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you to the witnesses who are here with us today. I would like to ask this question of Ms. Kaiser-Derek, who had started talking about something. We'll let her continue in this vein. I find your evidence interesting on the aspect of Indigenous women who are overrepresented in our Canadian prisons. That's an important aspect. And without being an expert on criminality in Indigenous reservations, I think that the preoccupation must be the same as outside these reservations. We have to find a balance between reassuring the population who's concerned about violent crimes and the increase of violence with crimes with firearms that we've seen over the past months, past years. We have to reassure the population, show them that we're concerned with that situation, and that we will try to find solutions, while being conscious that rehabilitation of the accused, the perpetrators, could, in some cases, go through another process than imprisonment. So, being concerned with this, Bill C-5 says we'll decriminalize. I'm going to talk just about firearms, if you'll let me. This is what concerns me the most. We'll decriminalize extortion with firearms, robbery with firearms, drug trafficking with firearms. This issue concerns a lot of people in Montreal communities, among others, and I think it must also concern people in Indigenous reservations. So, is there not a way of decriminalizing? Are there alternatives between complete decriminalization? Not decriminalization, sorry, between mandatory minimum sentences and the abolition of mandatory minimum sentences. For example, if we allowed judges to make an exception in certain cases, is that an alternative which, in your opinion, could be useful and could satisfy this need that we have of balancing the hot and the cold?
Text in question. I'll say a few things, just a few things that popped to mind while you're speaking. First, the Truth and Reconciliation Commission's call to action number 32 that I mentioned earlier, that directs the federal government to amend the criminal code to allow judges to depart from both mandatory minimum sentences and restrictions on CSOs with reasons. I think that would be a really valuable balance between some of the elements that you're describing, in the sense that it does place a lot of trust in judges, and there can be public education that is associated with that in terms of helping to instill trust in judges in the broader community as well. But the Truth and Reconciliation Commission, in that call to action, by expanding the ambit of judicial discretion in cases where judges choose to apply it with reasons. I think that the provision of reasons there would allow judges to engage with some of the issues that you're describing. And in specific reference to Indigenous over-incarceration, which is my primary concern in attending here today, there was one case in my work in which the judge noted that the method of analysis that was mandated by the Supreme Court of Canada in this decision, Gladue, this sentencing framework that applies to the sentencing of Indigenous people, the judge said that in performing that sentencing analysis, it will only have real meaning if, in appropriate cases, the judge, chooses not to send someone to jail for a serious crime.
Madame Kayser-Direct, je me permets de vous interrompre, désolé, mais on n'a vraiment pas beaucoup de temps. Et j'aimerais vous entendre davantage sur ce point-là. Est-ce que depuis la décision dans l'affaire de Gladue, où on dépose ou en tout cas on est censé...
I'd like to hear you say more about that context since Gladue. So when there are mandatory minimum sentences in Indigenous cases, has that not greatly improved the problem that existed earlier because of the heaviness or of the seriousness of the sentences? And if that's not the case, what's missing? What means that why is the Gladue report not enough? We have 30 more seconds, I'm told.
Or whether I understood your question fully, so I'm sorry if this doesn't answer. The end of your question, I heard, why is the Gladue report not sufficient? And if that is referring to what I just mentioned about the Truth and Reconciliation Commission saying in its call to action that judges should be legislatively permitted to depart from mandatory minimums and CSO restrictions with the provision of reasons, I don't know if that's what you're referring to, but those are separate.
Est-ce que ça règle le problème ou si on doit faire plus?
Does it deal with the problem if we need to do more?
To let you answer those maybe in his next round. Thank you, Monsieur Fortin. To Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I want to thank Mr. Fortin for raising what I'd rather be talking about, and that's the decriminalization of personal possession of drugs, and just remind everyone that there's a separate process and that private member's bill is working its way through the House in parallel. So I want to take a moment to let Mr. Mackey know he hasn't been forgotten, and I want to ask him a question about the rage all the rage that was going on in the United States for mandatory minimums for a number of years. And some of those jurisdictions, I think, including Texas, have really backed away from the mandatory minimums. And there's been a move, I think, in quite a few states to start doing what we're considering here, which is eliminating mandatory minimums. Can you say a bit about that experience in the U.S.?
Yeah, I would say, and again, no words whatsoever. I'm happy just to listen. You know, I've not seen anything quite like I've in Bill C-5. I think there has been some reconsideration at the federal level and throughout the country on, I think, a general obsession with mandatory minimums. But I think the country in the United States is still pretty locked into them. And I guess that's how I would look at this. In somewhat even sympathetic terms, like it's a great idea. Like if it worked, it would be really great. I think the experience of the United States shows it has real problems. And so again, while we're tinkering, I think, and recently in this current crime increase, I believe a lot of those discussions have really stalled. I'm very interested to see how this plays out in your country.
I guess in part of your presentation, you talked about there being no crime reduction benefit, no public safety benefit, and increased expenses. So that's based on the actual experience in a number of states. Is that correct?
That's based on the research. This is where probably the biggest disconnect in research and evaluation and policy is in mandatory minimums. At least in the criminal justice system. Again, the research is pretty clear, and it's often not super clear. In terms there's a lot of times findings are mixed. But in terms of what I told you in my testimony, that is a consistent finding of research over several decades. And so this is where policymakers in the United States have not generally listened to that research.
Thanks very much, Mr. Mackey. I want to turn to Ms. Kaiser-Derek on the question of Gladue, and maybe we've passed over too quickly, so I want to give you a chance to maybe state the obvious to all of us, and that is that mandatory minimums prevent the application of the Gladue principle and prevent actually achieving more positive outcomes for Indigenous people. Is that really your experience?
Sorry, I just had to unmute. Thank you for that comment. First, I should say I have not studied mandatory minimums, so that's outside the scope of my research, but I can still respond in a way. Yes, what you're describing is absolutely what happens in that judges are required through the Gladue framework, which derived from that Supreme Court of Canada decision that interpreted Section 718.2e, which is the code provision that indicates that judges must consider alternatives to incarceration, and especially for Indigenous persons. And so with that framework where judges are mandated to look to alternatives to incarceration, and especially for Indigenous persons, and then Gladue, the Supreme Court of Canada decision that contextualized that within the context of the over-incarceration of Indigenous people specifically and the need to respond to that. In the case of mandatory minimums and also restrictions on CSOs, judges may and do go through that Gladue analysis, and yet there then is no alternative except incarceration because of mandatory minimums and restrictions on CSOs. And so then in that sense, the Gladue analysis, even when performed, can't take effect. And if it's not able to meaningfully impact what sanction is ordered, then of course the problem of Indigenous over-incarceration is just perpetuated.
And in one of your last questions, you talked about severing community bonds. And there's this kind of idea that the system treats everyone equally, so that if Indigenous women are sentenced to incarceration, that's the same as someone else being sentenced to incarceration. But when we're talking about rural, remote, and northern communities, can you talk about the additional impacts that take place?
Absolutely. I'll try to find it really quickly, but there is one case that I'm thinking of in particular from my work that your comments remind me of, where I'm speaking while trying to look for it. Oh, here it is. One judge, for example, noted that for the Indigenous woman being sentenced in that case, the judge examined the potential impact of an institutional sentence on her family, including her children, because she would be incarcerated far away from them. And the judge decided that this would be an excruciating punishment for this Indigenous woman, above and beyond what would be faced by any man sentenced to jail or any woman sentenced that would be able to serve a prison term nearer to family. And the judge, sorry, I'm getting some background noise. The judge.
Your time is up, Ms. Kaiser-Derek.
Oh, I'm sorry.
Yeah,
okay.
No worries. Thank you, Mr. Garrison. And next up, we have Mr. Morrison. And just the next rounds, I'm just going to shave off 1 minute and to make them 4-minute rounds, and then the last two ones will be 2 minutes instead of 2.5, just so we have about 6 minutes at the end to discuss the duration of some meeting committee business. So over to you, Mr. Morrison, for 4 minutes.
Thank you, Mr. Chair, and thank you for the witnesses for coming. And I do have, I guess just want to talk about the conditional sentencing, and so Ms. Kaiser-Derrick, I'll be asking you particularly, but I think there's a lot of Canadians that would be surprised that issues like sexual assault, kidnapping, trafficking in persons, abduction of a person under 14, assault causing bodily harm with a weapon, assaulting a police officer causing bodily harm with a weapon. Now, that was a real shock. And to have some of the individuals be given a CSO going back right into the community or neighborhood they came from, I'm not so sure that that's a healthy environment. But I know that you've done a lot of research on CSOs, but I'm really interested in your research for the overrepresentation, and it hasn't come up yet, and I'm sure you're well aware of restorative justice. And we had a previous individual, mayor of Montreal, who brought up the fact that really we need to actually have crime prevention, not necessarily reduction by putting people in jail. So crime prevention and restorative justice go hand in hand. I've worked a fair amount with restorative justice in the past. And, it was interesting, too, that it was a 15-year project that Montreal did on youth as young as 5 to talk to them all the way through as they're growing up to actually show them there's another way forward versus organized crime and gang activity. So I'm wondering if you can elaborate a bit on your success with restorative justice, and especially with the overrepresentation of Indigenous females, how we could move forward without even having to talk about mandatory minimums or CSOs.
Sure. I haven't done any direct work with rehabilitation myself, but I will say that in the cases that I studied, sometimes judges, I noticed that judges would characterize prison as a source of treatment for rehabilitation needs of Indigenous women. Other judges located those rehabilitative needs in the community. And I think the former construction is problematic, as there is just so much research to support that incarceration harms rather than rehabilitates. And in terms of Indigenous women, something struck me when I was preparing to speak today. I was looking at the Aboriginal Justice Inquiry of Manitoba report, which came out in 1991. And it's a very extensive report, and that was over 30 years ago. And the commissioners write in that report that they were moved by the situation of Indigenous women and noted that they suffer, I'm looking at the wording now, they suffer double discrimination as women and as Indigenous people, as victims and as offenders. And that when speaking with women in the system, the commissioners of this report write that they were convinced by the arguments of Indigenous women that a restoration of their traditional responsibility and position of equality in the family and community holds the key to resolving many of the problems they've identified.
So would you agree then that restorative justice, I guess you're just not familiar with that program, that would be probably your first diversion, your first route to take when someone comes before you?
I am certainly supportive of, absolutely would be supportive of restorative justice approaches,
so basically
anything that would keep Indigenous women out of the system.
So we should put more funding into those sorts of avenues, I guess.
I would certainly support that.
Thank you. Thank you, Mr. Morrison. Next to Ms. Dillon for 4 minutes.
Thank you, Mr. Chair. My first question is for Mr. Mackey. Could you please elaborate a little bit on the fact that you said mandatory minimum sentences is a misnomer? If you could please explain a little bit to all of us what you meant by that. Thank you.
I think absolutely. So I think using the word mandatory, it sounds like it'll automatically happen. Everyone who commits a crime under mandatory minimums will be mandated to serve a certain penalty. And that's precisely what the research on mandatory minimums decades of research show it actually does not happen. There's all kinds of evasion that occurs at the system kind of practice level. And so mandatory minimums aren't actually mandatory. So that's what I mean by that.
Can you give us examples, please, of evasion?
Sure. So any penalty, a lot of these are, the research has been done on this from varying lengths of time, from kind of long sentences to shorter sentences. At the arrest level, if police feel as if, again, the penalty will be unjust, so they don't want to do it, they just don't make the arrest. If it comes into court, who's ever in charge of charging, they can move the charge around. At the trial level, you will see more dismissals or pleading to offenses that they don't have the mandatory. So you'll see it like that. And I think you'll also see it used as to coerce plea deals in some cases. And so for people who make it through the system, actually through the prosecution phase and into the trial, in the conviction phase, tend to have longer sentences. So again, there's nothing. I think that the thought behind mandatory minimums is that we can kind of get rid of the complication of the hard work of dealing with crime. And just kind of make it clean. And what the research shows consistently is that mandatory minimums just actually make things more uncertain, less predictable. They breed distrust within the system itself, within people who are dealing with it. And in that sense too, they tend to kind of perpetuate the same sorts of problems that generate mandatory minimums. People in the public, law enforcement, public officials, seeing sentences that don't seem to match the crime. And so I think, as far as I understand the conversation today, it's not an issue of, are these kind of crimes, like, can someone be sent to prison for them? That's not what's at issue. The issue is, can judges have reviewable discretion to make different kinds of choices?
Thank you. And something you said actually just brought back to mind another thing you said. You spoke about racial and ethnic minorities experiencing more disparity when it comes to minimum sentencing. Can you talk about that as well, please? And also, if you, in your study, you've noticed that these mandatory minimum sentences are applied more to people of, let's say, those in financial difficulty, where it's easier for them to just plead guilty, because we've seen it happen. I practiced as well and often saw these things. So if you can please talk about that. Thank you.
Yeah, no, glad to. I think it's a pretty consistent finding in the research that, again, I think mandatory minimums are predicated upon the idea of consistency, predictability, and it kind of breaks those mechanisms, or at least it challenges them in any way. So a pretty consistent finding is lots of disparities with region, with courtroom, but also higher concentration, people overrepresented. In the United States, the U.S. Sentencing Commission found that African Americans were more likely to receive mandatory minimums. And I guess the way that I would look at that isn't to necessarily, accuse the system of being malign in some ways. I think this is the work of implicit bias, and also why you want to have reviewable discretion. You want to know how these kinds of decisions are being made, so you can fix them. And when you vest discretion in areas where you can't see that, where you don't have that kind of accountability, that's what precisely allows that kind of discretion to fester.
Thank you, Tatum. Thank you, Ms. Dillon, and thank you, Mr. Mackey. Next to our next round, two short 2-minute rounds, beginning with Monsieur Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. So in 2 minutes, Mr. Mackey, the question is for you. I'd like to know, I know you have a law degree and also philosophy degree, and your practice brings you to work in the field with the population. And let's leave aside for now, we're taking for granted that mandatory minimum sentences are a bad thing. We'll just take that for granted. So what's the message sent to the population by the legislator? That has a certain importance. And I'd like you to know whether there's cause to be concerned if currently there's a number of mandatory minimum sentences for the firearm situation. Mr. Morrison made a list of those: extortion, robbery with the firearms. There's an increase of violence with firearms everywhere, and including in Montreal. So is there a way of finding a intermediate solution while according some flexibility to the courts, but not sending a message that we are being nonchalant or uninterested, faced not by crime, but by the concern of the population about crime. So a kind of a middle solution for some serious crimes to give judges the possibility in exceptional circumstances to make an exception from the mandatory minimum sentences. Is this an interesting solution in your opinion?
I apologize. I only caught the last bit. I didn't realize there was the translation, so I'm very sorry. But I think I got the gist of your question. So I hesitate to talk too much about the Canadian system, which I've read about. I don't understand. I'm not an expert in it. I think in the United States, I would say, the research really points to at a legislative level, creating structures for discretion, the ability to depart downward, so to have some like presumptive minimums is a term that's often used. But I think what you're talking about is the hard work that you all have as lawmakers. Your constituents ask you.
Thank you, Mr.
Sorry,
Mackey.
yeah.
I appreciate that. Next, thank you, Monsieur Fortin, and over to you, Mr. Garrison, for 2 minutes.
Thank you very much, Mr. Chair. Just the last 2 minutes, I want to go back to Ms. Kaiser-Derek. We've had the Conservatives today, again, talking about criminals and non-criminals and listing the terrible crimes that we're going to exempt from mandatory minimums. And my question is about the nature of the Indigenous women who are involved in crime. So what proportion would you say were the major perpetrators themselves? What proportion were those where the crimes were dictated by their circumstances? And what proportion where others influenced them to engage in criminal activity?
Thank you for your question. I would say it's difficult to categorize my research in those terms, other than to say that it was very apparent that the colonial context was completely embedded in their experiences of victimization and criminalization, and how their victimization and criminalization intersect. So I'm not sure if that fully responds to your question, but that's my primary observation.
And so what you're saying, I'm trying to, being a former academic at UBC myself, trying to say is that circumstantial factors often come into play with Indigenous women when they come into conflict with the justice system.
Yes. Again, I'm not sure exactly how to respond to your question, but certainly there are gendered contexts that also intersect with this colonial context that are interrelated with women's offending and Indigenous women's criminalization. And like, for example, I mentioned in my statement in opening that some of the women in my research became criminalized because they were afraid of contacting police or medical authorities because they were afraid of their children being apprehended by the child welfare system. And so in that sense, their criminalization was entirely linked with their colonial experience.
Thank you, Ms. Kaiser-Derek, and thank you, Mr. Garrison. That concludes the second panel, and I want to thank all the witnesses. And we just have some community business to do. So you're dismissed. You're more than welcome to log off. In the meantime, we'll hopefully do this quickly. Members, I think the main topic is just the amount of meetings we should have on the study, and I think we hadn't concluded on that. And so I'm hoping we keep the debate to a minimum, and then we can vote it. So anybody want to go first on that in terms of how many meetings? We've done 4, just for the record. This is concludes the 4th meeting. Mr. Moore?
Thank you, Mr. Chair. As Mr. Fortin had suggested, I would suggest, we've done 4, I would suggest that we do 4 more for a total of 8, and then witness meetings, and then have I would think a bill this size, 2 meetings set aside for clause by clause if necessary. If we get through in one day, then we're through, but I would think 2 meetings to get through clause by clause.
Okay. Monsieur Fortin?
Oui, Monsieur le Président.
Yes, Mr. Chair. We're talking about how many meetings we'll have. That's good, but I'm also interested in what we'll do with those meetings. Now I see that we have a certain number of witnesses that are announced who haven't testified. I know that I have another witness who will come, I don't know if it's Friday this week or next week. So there are witnesses we still need to hear. And I think that the bill is an important one and deserves that we spend the necessary time on it. I won't repeat what I've said already. We have to know that there are 2 bills. The Minister of Justice dumped that in our yard. So it's there's diversion measures and mandatory minimum sentences. We have to look at this properly. So are there other witnesses? Does someone else here want to call in more witnesses? And otherwise, how much time do we need to hear those people? That's what I'm concerned with. Then will we be able to do it in 4 or 6 meetings?
Mr. Clerk has informed us that by the witnesses that have been given so far by everyone, we would have them accommodated by May 13th, May 17th. That week, they should be done. So that's assuming the following week.
So how many meetings does that mean?
This Friday and
trois rencontres pour
3 meetings to exhaust the witness list we have. That's what you're telling us, Mr. Clerk?
Yes, correct.
Mais il me semble que j'en...
But it seems to me that I see a lot of witnesses on this list. Are you sure of that? In the list of witnesses, I'm doing it, I'm bound by dividing it amongst the parties. Well, the number's there, but I'm saying that it's open, what we've tried to keep distributed according to the parties. I'm bound by that. Well, I see 25 witnesses on my list in white, so they haven't yet been heard. So 25 witnesses in 3 meetings, is that not a lot? Could we not take time to hear them better? So we're not making people be witnesses to just say they came. We have to listen to what they say and analyze it. There are 25 of them, 25 lines there, unless we've removed some of them.
We'll get some more information, but based on, I think, the proportion from every party, I think that's what the clerk is implying, that we would be done by then. Mr. Garrison.
Thank you very much, Mr. Chair. I think we have to keep in mind that we have a private member's bill on decriminalization of personal possession, which might well end up in committee. We have hearings on a new appointment for the Supreme Court judge, which will most probably come to us within the next month. And we have other government bills that are still on the order paper. So I don't think we have unlimited time as the committee. I think we have to keep in mind we have other things that may in fact come to us. And so I was happy with 6. If we can exhaust the witness list at 7, I wouldn't be opposed to that. But I think we have to keep in mind that we have other things coming in the committee.
Fair enough. Mr. Nansangari.
Yeah. Thank you, Mr. Chair. I think we're also content with 6 meetings. I know we've had a very robust discussion. We've had a variety of diverse witnesses with very different perspectives, and I think it does provide the range of perspectives that are out there. So we would be satisfied with 6, as I indicated at the last meeting. But again, if absolutely necessary, then we are amenable to this to one more meeting, but it has to be provided that we've exhausted all the other witnesses, full panels for the meetings up to the 6th meeting.
Okay, Mr. Cooper.
Well, I'm fine, Mr. Chair, other than to say that if there are 25 witnesses, and I don't have the list right in front of me, it would seem that we would need at least 8 meetings. We've gone through an average of 3 witnesses per hour. I don't think it's really possible to hear from any more witnesses and then have sufficient time for members to ask witnesses the necessary questions. So again, it would seem on its face, based on that number, that 6 is completely inadequate, and likely 7 isn't sufficient either. I think we've got to do our due diligence and hear from as many witnesses as possible so that we can put forward the appropriate amendments and do our due diligence and do the work we've been called upon to do.
Mr. Moore?
Yeah, just thank you, Mr. Chair. I mean, I think we're all in a similar ballpark. I do, you know, when we think of the numbers and each party puts in their allocation, and that's probably why the numbers don't exactly mesh up. But I mean, I do think 8 is preferable and reasonable. I did want to mention, though, my suggestion of 2 meetings for clause by clause in no way to be interpreted as saying, well, if we're not done clause by clause, like we have to do our due diligence. We don't know how many amendments are going to come in from each of the parties. I suspect we will have some amendments, but I threw that 2 days out as a way of saying probably we could budget for 2 days, but not to say that it might take 3, but just point of clarification.
Okay. And last, Mr. Nansangari.
Mr. Chair, in the spirit of cooperation, and I think, you know, this committee generally does work quite cooperatively, I would suggest, and I'll be, you know, amenable to 7 meetings. And of course, I think 2 days for clause by clause is ample time, but obviously we'll know when we get to it. So if it's okay, if we can have consensus, then we can move forward to have the study on C5 completed on the 13th with clause by clause on the 17th and 20th with amendments. I guess I don't know what the protocol is, but I believe 24 hours ahead, so the 48. What happens on a weekend?
It's more tricky there. We'll have to check there, but the sooner the better, right?
Yeah. So I guess amendments to be submitted by the 13th, end of day 13th.
I think the clerk had asked if we can get amendments by the 11th, 12th, but I guess it'll be the 13th. Sorry,
the 13th, it will be the 11th.
11th.
You, the 11th.
Otherwise, the 13th, if it's the other. Do we have consensus for 7 meetings? I see some nods.
Combien de
How many witnesses will we be hearing each meeting?
Per day times 3 more, 18? Or roughly 18?
Donc, qui sont les 6 témoins?
So who are the 6 witnesses whom we'll be telling we won't hear you? Have they already been identified? Who will we not be hearing in this list? So I'm inviting them. Those who were not invited have not been invited. So I won't have to tell them that they're not coming. They haven't been invited. I'll do what the committee tells me to do, obviously. Well, I don't know how everyone's working, but if I put someone on the list, it's because I've spoken to that person and they're ready to testify. So we'll wait for you to call them. I don't convene them officially, but they're expecting to be convened. If they're not expecting to be convened, well, then it's not so bad. But if they're expecting to be convened, well, I see that a lot of them asked to come and speak. And maybe that's where we'll be cutting things. The way I see it, the list that you have, I always send you the list of people who want to appear and the list submitted by the party. Sometimes it's not the same thing. Sometimes people are asking to speak and they haven't been invited. So I just invite the people according to the parties, the ones who were invited by parties.
Monsieur Fortin, I think we have consensus. I saw nods, 7. We'll do that. And then just lastly, in regards to TRIP, I think the deadline is Friday for me to submit. I had sent it out to the vice chairs. I didn't hear back, but I spoke to both of you. I'll send you details of a proposed TRIP, which we can amend by if we can agree to submitting to that by Friday. That's the other course of business. So I'll submit that by the end of tonight or in the morning if I can, and then we'll go for there. Mr. Nansegari?
So just to clarify, maybe the clerk could give us the timeline for amendments to be submitted, the specific time?
So what's the clause by clause? So when, I'm not sure that, so when we'll begin this clause by clause?
So we will go on till the 13th, I think.
Witnesses, including
Witnesses,
witnesses, okay?
yeah, and then clause by clause will be.
On the 17th.
17th, yeah.
But again, just so we're clear, like, if we're not done on the 20th, then we're not.
And you
because
will
we're
have
not
to
putting
work
in a
on it,
hard
correct,
cap,
Chris.
Yeah, for the record.
I'm hoping not to come back during the break week and do it, but we'll try to.
So let me clarify that. I will send an email first thing tomorrow morning to all members.
Okay. All right, if nothing else, that concludes. We'll see you Friday.